Se informa a los asistentes que el acto va a ser grabado y podrá ser difundido en todo o en parte a través de su página web con la finalidad de divulgar en el seno de la propia universidad y en la sociedad en general la actividad desarrollada. La legitimación de la Universidad de Granada para el citado tratamiento de datos personales es el cumplimiento de una misión realizada en interés público o en el ejercicio de poderes públicos conferidos al responsable del mismo, de acuerdo con el artículo 6.1 letra E del Reglamento General de Protección de Datos. Las personas interesadas podrán ejercer sus derechos de acceso, oposición, rectificación, supresión o limitación del tratamiento de sus datos, tal y como se explica en la información adicional que está a su disposición en la página web de Secretaría General de la Universidad de Granada en el apartado de protección de datos. Las personas que no deseen ser grabadas podrán acomodarse en las zonas delimitadas fuera del campo de grabación. ¿Todas dan su consentimiento? Good morning, ladies and gentlemen. It is a real pleasure to introduce you today to Professor Tania Sourdin and Professor Jonh Zeleznikow. Today we are going to develop a new session of the talks with the Unidad de Excelencia, Digital Society, Protection and Security of Rights. The topic of this talk is technology used in the judicial arena and judging. For this, to develop this talk, we have the Professor Jonh Zeleznikow. This is visiting scholar at the University of Granada. And especially today, we have Professor Tania Sourdin. Tania Sourdin is the Dean of the University of Newcastle Law School and has a background as a litigation lawyer and mediator, has a PhD in commercial dispute resolution, and is the author of more than 140 publications that include books, articles, and papers that are focused on justice reform issues. She has published and presented widely on a range of topics including ADR, justice innovation, justice issues, mediation, conflict resolution, collaborative law, artificial intelligence, technology, and organizational change. Recent books include Justice Technology and AI and Justice Apps. Tania has led a range of research projects, including 2 that develop AI systems in the justice sector, is currently leading an international survey of more than 500 judges that explore how judges are using technology. Tania sits on a number of boards, is a fellow of the Australian Academy of Law, and is a visiting academic at Oxford University from October 2022. And for me today, it's a real pleasure to have Tania Sourdin today in the University of Granada, where she was a milestone also with Jonh Zeleznikow in building our Guide for Digital Justice that was presented this year in May, supported by Fundación Cotec. And for today, Tania is going to explore and to show us how judges use technology, and in particular, how forms of AI may reshape judicial approaches and the judicial function into the future. Please, Tania, I'm giving you the floor, and thank you very much for being here today with us.
Thank you very much for that very warm and generous introduction, Fernando. I am absolutely delighted to be here with my colleague, Jonh Zeleznikow. And John and I have had an opportunity to work together on a number of occasions over the last more than 2 decades now, John. And it's a real pleasure to be here and to visit and enjoy the warm hospitality here in Granada. It's a particular pleasure because although I think many people might look out the window and think it's quite cold and wet here, I have arrived from Oxford yesterday, where I'm telling you that it is colder and wetter, so it is a real pleasure to be here today. I'm talking about technology use in the judicial arena and AI judging, a topic that I'm fairly passionate about. And last year, I actually had a book that came out on this topic. And I think it's a fascinating area to think about how judges are using technology currently and how technology may reshape the judicial function into the future. This book had followed a number of other books that had arisen in part from a collaborative research network that I run under the auspices of the Law and Society Association that has about 120 scholars around the world involved in it. And I previously edited a book called The Multitasking Judge and another one on the Responsive Judge. This one I wrote myself, it wasn't an edited book. But I just draw your attention to those two previous books because I think what's really interesting is that judges don't just adjudicate, they don't just make decisions, and they play a very important role in any democratic society. And I think it's really important to remember that in the context of thinking about how AI may change the function of a judge into the future. And also, I think to perhaps overcome some of the, what I would call AI euphoria or AI hype, which is this notion that people can be completely replaced by technology. So although I think some replacement is probable and likely, it's really a question about how that might happen. I think interestingly, and the only reason why I've got a picture of my book up on that on the screen at the moment is that the artwork that you can see on the cover, which is no doubt quite derivative, was actually created by a form of AI. And it's interesting because we often think that AI can't be creative. But on the one hand, while I didn't want to, if you like, overthink the AI hype angle insofar as judges are concerned, there is capacity for AI, I think, to be creative and to do things that we humans didn't think were probably possible even 5 or 10 years ago. So in the background, if you like, of the material that I'm talking about today, I am, currently at Oxford, and what I've been looking at in Oxford is in part the relationship between judges and technology and the role of AI into the future. And more recently, I've been writing on neurotech, which is more around how judges might even be enhanced into the future or how you might change appointment criteria. I won't go too far down that track, which is a bit of a Star Trek adventure on its own. However, I do want to point out that some of my thinking is informed by the very different jurisdictional responses to the judge AI phenomena around the world. So within Europe, all of you are aware, there are these extensive regulatory responses to AI more generally, and a lot of work has been done on ethics, and there's also these extensive regulatory regimes that have developed. The GDPR is a really good example because when I've asked questions of people about the GDPR and how it might work, it will limit the sorts of data that can be collected. And I did say, is there a carve out for researchers so that we can actually access some data, even if it hasn't been labelled as being for that purpose? And I think it's actually going to be quite problematic. So my initial comments are what is taking place in Europe at the moment, and even the proposed AI Act, are likely to have significant impacts in Europe. However, I don't necessarily think that those impacts will be extended throughout the world. And of course, there's a lot of discussion on the Brussels effect and this notion that things happen in Europe and they influence what happens around the world. My sense is that a regulatory response will not be as pronounced elsewhere. It certainly won't be in the US, and I don't think it will be in my own jurisdiction. I'll touch briefly on what jurisdictions such as China are currently doing in this area because I think it's interesting, but I do think there's a concern that what happens in one jurisdiction might be transplanted to another. And in that regard, I'm talking more about China than the EU regulatory responses. The responses in some other jurisdictions, such as the US, to, if you like, the judge AI phenomena, but also in relation to how technology is used within courts, are also radically different from the responses in a jurisdiction like the UK. So in the UK, where Richard Susskind's work has had so much sway, you can see that there is this idea that you develop a court system where two tiers are really not managed at all by the judges and are focused on dispute resolution and dispute prevention. And you have a third tier, which is reserved for adjudication. And some of that adjudication will be done by forms of AI. That's the UK, if you like, Her Majesty's Online Court proposals that are really currently being embedded. Somewhere like the US, you have a view that you can have much more incremental change, you can change case management, and the courts will change and vary in quite a different way. So each of these changes means that it's quite difficult to talk about this topic area, because it's the same as talking about anything into the future. You have these very different approaches, if you like, to technology that are emerging around the place. And it's therefore hard to actually ascertain what direction we'll take. I'm going to talk more about perhaps some of the possible options, as well as some of the work that I think has been uncovered recently. Now, normally when I talk about technological change, I devised a structure probably close to a decade ago now, where I divided up technological change into three areas. One of them is supportive technology, one is replacement technology, and one is disruptive technology. And there are no necessarily bright lines between each, in that you can have technology that's developed that is both supportive, replacement, and potentially disruptive. But this framework really assists when we're talking about regulation and when we're talking about options for the future. And so supportive technology is what I'll touch on first, and how judges and courts are using supportive technology. And that includes much of the work that in particular has developed over the COVID period. And that work includes, of course, using Zoom conferences, using Teams, having different ways of exchanging documents, looking at some basic apps. So I'll talk about justice applications that are available often for people on their phone. And in some jurisdictions, and my understanding is in Spain, for example, you can't really do that much on the phone at the moment when you're engaging with a court. However, if you were in some jurisdictions in China, you could run your complete court case from beginning to end on your mobile phone. There would be an app that you can use. It's a particular app, and I've written about it and worked with Chinese scholars on this app and how it works. And all of your documentation and everything else would be lodged and filed via your app. You would take photographs of things if necessary, and everything would be converted to a text format. That's an example, if you like, of supportive technology that also moves a little bit into the replacement technology area, because you don't need real life humans doing the case management work in the background. A lot of it is really being done by the app, which has a triage function. And you've also got potential AI functions that have yet to be built onto many of the Chinese systems. The replacement technologies, they've really been mainly in the court system linked to case management, where you've got automated emails, you've got listing sharing, you've got everything from telephone dispute resolution systems, you've got ODR, and you've got what was done by Modria, but also now Tyler Technologies and some of the work in that area. Again, British Columbia, it's a good example of an extensive use, if you like, of these replacement technologies, where what you have in British Columbia, and I think the CRT system, is an attempt to build a whole new tribunal system, which is really has a number of some sophisticated, some pretty unsophisticated technological tools. I'm going to talk about that briefly in the context of a divorce app in Australia, which has a paralegal AI and an accounting AI system, which is built onto that app. And then finally, we've got the disruptive technologies, and that's really where we're looking at much more developed and sophisticated forms of AI, but disruptive technologies, of course, exist beyond AI, although most AI feeds into a lot of that disruptive technology work that's happening. And I might touch briefly on neurotech, only because I'm looking at it at the moment, and I just think it's fascinating in terms of what it might do. To give you an example of neurotech innovations, for example, you can have now external devices which can tell whether you're paying attention. And if you're not paying attention, you can have a scent that is automatically released through another device that you have on your body. which is intended to keep you more alert and more focused. That's a an example of a very primitive neurotech approach, but you can imagine a judge using that potentially in a hearing as the judge starts to drift off to sleep or whatever a judge might do. I should say that I've also held a number of tribunal positions over my career for more than 20 years. And for 14 years, I was a part-time member of an appellate tribunal body, which considered other. So I know of what I speak in terms of perhaps not staying awake and alert in a hearing. So I'm going to sort of touch very briefly what's driving change. Clearly, we're more connected than ever. There's more connected devices on the planet than toilets. It used to be about, I can't remember what the exact figures were, but it's now more than double the number of toilets with connected devices, if that's one landmark. And we know now that a large percentage of the population is online all the time, and that's only increased over the COVID era. There's also, of course, huge potential and scope for external dispute resolution and online dispute resolution. And again, that's around cost and time savings primarily. Not having to have to physically go to a place can be very important. It can be even more important in some jurisdictions than others. So in my own jurisdiction in Australia, we have very significant geographical distances. They can keep us separate from the rest of the world, and even within our own country, it can take days to travel from one part of the country to another. Having technology which enables you to meet virtually has been of enormous benefit. In a country such as Spain, where things are a lot closer, it's perhaps easier to actually meet face to face. However, my understanding is that also here it's been a significant benefit to be able to bring people together online. Now, you do lose a bit of what happens in the online space. And I certainly know that in the context of my university work, you lose the incidental conversations, you lose opportunities to connect in ways that are quite different from what happens in the online space. However, overall, for many people, being able to resolve a dispute online can be fast, it can be simple, and can be quite useful. Now, there's a couple of articles that I've written more recently. There's one called Mediating via Zoom, which I think came out at the beginning of this year. John, I can't remember when it came out, but it's it really points to some of the highlights and the advantages of doing things via Zoom, but also discusses the disadvantages. There's another article that I wrote in 2020, which is called Death Sentencing via Zoom, in response to a couple of people who'd been sentenced to death at the early stages of the pandemic via Zoom, and my considerable concerns about really a person being sentenced to death through a technology like that, rather than having an opportunity to actually have an in-person experience. So there's convenience and comfort with some online options, and without a doubt that is reshaping what we're doing. The question is really, I think, around where we draw the line and where we say it's not appropriate. So there are triage questions that are appropriate to ask when we're looking even at supportive technologies. There's quite a lot of obstacles in terms of justice reform, and we were briefly talking about that today around innovation readiness. Those obstacles exist. There is a conservatism in law which exists. On the one hand, that can be quite useful because it means that I think when there are changes, hopefully they're thought through, and because we're a much more conservative, if you like, scholarly community and profession on the whole, I would hope that it means that we consider things in a more calm and patient manner. There is, though, I think, an increasing movement in some countries around the world to really limit the role that judges play in a democratic society. And that actually means that we have to be careful around who's doing the reforms and how the system is being designed for the future. So I'm going to touch first on the sort of pathway of reform. I think many of you are aware that it's only been 15 years since we had iPhones, and now we're all addicted to our smartphones and we can't even imagine a world without them. I want you to encourage you to imagine what could actually happen over the next 15 years, because what has happened over the last 15 years has been revolutionary, and most techno-futurists will predict that we're only at the bottom of the curve in terms of tech reform. So whilst not trying to engage in AI euphoria or AI hype, there is a lot of change still to come, and that will reshape how we're looking at things. So we need to now be, I think, very careful around how we actually talk about justice reform. What are the objectives that we're trying to receive from these reforms, and how can we build a system that is future-proof, or at least enables changes to happen that are sensible and appropriate. It's only been about 27 years since we've really had much technology in courts. Prior to that, everything was done on paper. Now, and I think, you know, the almost laughable piece about technology in courts was that, in fact, if you look back at court decisions and you look back at even legislative material 50 or 60 years ago, it tended to be very slim. There really wasn't very much that came out. A lot of material was 2 or 3 pages long. Unfortunately, technology and the word processes has led to trial by trolley and has led to more paper rather than less, and has also led to these incredible outpourings from sometimes judges, so that what might have been written in 2 or 3 pages 30 or 40 years ago now consumes 120, 150, 200 pages. And, you know, that's really been enabled by technology. And unfortunately, that's led to, in some instances, more paper rather than less. And query whether it's actually been more thoughtful, in that we seem to forget some of what we've actually done in the past anyway. It's only been 23 years since we moved off modems. Some of you will remember that, you know, you had to plug your computer in, you had the telephone call. There's a recording of it on that website in case you're feeling nostalgic one day. But it really has changed the world now that we've moved to a much more connected broadband, connected internet, and fibre optic cable has really shifted the way that we think. About 35 years since we had supportive technology first in courts. And so supportive technology 35 years ago was actually a video or something like that that you might get sent by a court, which actually showed you what happened in a courtroom or what you could do. So that was pretty exciting. Again, about 9 years with textual analysis. It's about 24 years with AI using branching technology. And that is really where Jonh developed a lot of his expertise and has been a world leader. About 8 years since we've had more sophisticated technology again, so it's pretty recent. And it's about 7 years since we've all started to have wearable tech, which will change the way in which evidence is gathered, and it will change the way that we think. Many of us now have a smartwatch. You know, even 5 years ago, it was unusual to have a smartwatch. So my questions are, and some of what I'm saying is really around like what's going to happen over the next decade and what might we expect. Now, in terms of what we might expect, I'm just throwing this out there in the context of supportive technology. So this is actually a photo of me and a colleague of mine in my university foyer in Newcastle, Australia. And the reason why I've put it up there is because just recently I also used it's kind of a micro expression tracking software, yeah, and it can detect emotion amongst other things. And you can see that when it was detecting my emotion here, I'm sort of disgustedly surprised and happily surprised at this emotion micro expression tracking software. The reason why I'm showing you this is because about 8 weeks ago, I actually used this software with judges in Singapore. And I use this software with judges in Singapore because I was very curious that they're trying to set up a more therapeutic family court. And I was really talking about what do people perceive when they come into the court system. And so the reason why I'm showing you this is to say, looking at supportive technology actually can create a whole lot of different ways in which judges engage, because it can track forms of engagement in quite different ways. So don't think about supportive technology just in terms of changes, think about it also in the context of research. Now, I have to say that if I was doing identical research here in Europe, I would probably have some difficulties because of your regulatory environment. And I think that's fascinating as well, that your regulation, although I don't think it was intended perhaps to prevent some research from taking place, that might actually be the outcome. So these kind of supportive technologies, and I call them supportive, where you've got analysis of micro expressions, are interesting because they will change how courts function. They're likely also to have an impact, I think, on alternative dispute resolution processes, but more importantly, there'll be an impact in terms of research. When I'm saying that, I'm thinking in particular, you know, one area that I looked at, and Fernando would be interested. I have a PhD student who recently finished her PhD on what makes a mediator effective. And I would love to have, as a researcher, actual material which tracks people's micro expressions, so you can actually think, well, what engagements made a difference? What was it that changed perhaps the way that people behaved at a point in a mediation or at a point in a court hearing? So I think we'll see more research which is really using some of these supportive technologies that enables us to better understand what happens in a court environment and also what happens in an ADR environment. I think some of this technology is still a bit dodgy, and that's an Australian word to say that it's not necessarily all that valid. However, having tried it out myself and having tried it out on others, I think it can reveal some really interesting material about what is happening to people when they're going through a court experience, how they're experiencing the justice process, and also perhaps what might change. In the context of replacement technologies, we're going to see, of course, considerable growth, and the significant growth that we'll see, I think, over the next decade is more in the supportive and replacement technology area. We'll see more of this large-scale online dispute resolution. And at the ADR conference that Fernando attended just recently in Oxford, we heard that there is some class action pieces going on about some of these large-scale ODR schemes. So we'll see how they pan out. Of course, in the US, there's this focus on often forms of arbitration that are really not what we would consider to be really justice processes in the same way. However, the reality is, in the context of replacement technologies, at some point, my virtual assistant might, for example, if we have a consumer dispute, engage with your bot and sort things out based on my preferences that my virtual assistant already knows about. And I might not even have to be involved in a complaints process, because in a sense, it's all happening independently. So there's going to be, I think, a massive increase in these AI-powered assistants. And it raises interesting issues from a legal perspective about agency and around free will and the extent to which I'm involved or engaged in it. So we're going to see, I think, a lot more of these chatbot plus systems that I call. So a lot of the chatbot systems in the past, pretty primitive, not really that developed. You had like human chatbots often in the, about 8 years ago, mainly human chatbots where, you had one live human who was dealing with 8 conversations. Now we've got powered chatbots that are actually able to do much more, some very primitive and some now getting quite sophisticated. We're going to see a lot more in the context of e-courts and e-arbitration, sometimes with big providers being linked in, and Her Majesty's online courts. We've already seen e-discovery, and we'll see this increase in private providers, which does have impacts in the context of the justice system, because you're looking less at state providers and more at private providers. And again, there are some issues there, particularly with the large digital Switzerland, I'll call it, the big corporations. And then we'll see the boutique providers, and I'm going to talk about one of those boutique providers with a very short video, which is called Adieu. And I'm only talking about that one not to sell the service or promote it in any way, but because I evaluated that particular app in 2019 and 2020, and I think the way that they've developed is interesting as a researcher to look at it. When I started looking at justice and ADR apps in Australia in about 2019, there were about 40 apps that were available on your phone. When I stopped, there were about 280. So there's massive growth in what are really supportive and replacement technologies that help people move through the system. Now, some of those are very much developed out of the court system. Many of them don't have much judge-led, if you like, progress. It's mainly being developed in the legal sector. However, there's also capacity for these types of apps to impact on judges and to influence the way that judges do their work into the future. And then you've got a whole lot of government initiatives, and a lot of those have been failures, quite frankly, so far. A lot of them are really trying out technologies on the most vulnerable people in the society. We've had the robo-debt disaster, which was really a data matching scheme in the social security area in Australia, which led to many people receiving a notice that they owed huge amounts of money, and it was often incorrect. And as a result, we have a current Royal Commission underway into the robo-debt process. Australia has taken a much more relaxed approach to, I think, the use of technology in government decision-making than would be accepted in most places in the EU. And that's been problematic, again, because sometimes the systems that have been rolled out have been very primitive, been inappropriate, and have been focused on the most vulnerable. A lot of the visa-making processes, though, around the world are driven by some of this inadequate tech, and you've only got to apply for a visa in another country to actually see how poorly put together some of that tech is. I actually got knocked back for a visa to Canada, which was laughable, I thought, because I was going over there to facilitate a group of judges to do some work in Canada, and I got knocked back. It was maybe 2017. And the reason why I got knocked back was because I use a Firefox browser, and I always do that because I don't like to be tracked everywhere that I go. And when I filled out the visa application, apparently it didn't line up correctly with the Firefox browser. And unbeknownst to me, it came back that I had undiagnosed tuberculosis, it said that I had. And so I was told, without any explanation, that I had to drive 160 kilometres away and see a doctor and get a report. And I just wanted to find out why I kept getting knocked back, because I applied another 4 times and then got quite a rude letter and was told that the only thing I could do was appeal to the Supreme Court in Canada about my visa refusal, which again was very ironic, given that I was actually going there to do work with judges. And it wasn't until I eventually got to a human, which was incredibly difficult to do through their system. And it was only because I knew people in Canada that I ever got to talk to a human. But it really highlights how defective some of these systems are. I was just pleased that it came up with tuberculosis, because the next option that could have been ticked, because I was using the browser that it didn't like, was untreated syphilis. And that would have been much more embarrassing to deal with than tuberculosis, which I clearly didn't have. So I'm going to talk a little bit about, again, in the context of supportive and replacement technologies, one app. Now, this app was actually developed in 2016, and this video is a little old because it's 2018, 2019, but I want to talk about where this app has gone to from here, and to contextualize that in a sense, to say, okay, well, this is where it's got to now. What does this actually mean for the court system, and what might this mean for judges? So it's quite a short app, and again, I'm not trying to sell the services in any way.
In every relationship, there are fine times, and there are times when things get... If it breaks down, the separation cloud. It gets complicated. You don't know who to trust or what to do next. You want what's best for everyone, especially if you have kids. You're worried about assets, money, the future, and the separation cloud casts its shadow over everything. In the family law courts, if you start the separation process now, your case may not be heard until the 2020s. It's unsettled on the financial front too, with the average Australian separation wasting a third of everything you have. But there is a ray of hope. That means your dark days can now be sunny. It's a new system called Adieu, and it's your path to positive separation. Simple, intelligent, find your way forward with structured steps to a brighter future. Adieu brings 4 types of expert together with the power of artificial intelligence and the benefit of common sense. Lawyers, coaches, mediators, and accountants who guide you through the process. This low-pressure system puts you in control with unique technology that makes the process unbiased and actually more human. You know exactly where you stand, so you can see clear skies ahead, with a plan to resolve your situation in as little as 4 weeks. Invite your ex-partner into the process and work through it independently, or with the support of an impartial expert and lawyers. Property and parenting agreements are legally formalized with intuitive digital tools helping you reach agreements on what's fair and what's feasible without clouding your emotions. The best part is you can start to create your plan forward right now in just minutes. All you have to do is have a quick conversation with Lumi, the world's first family law robot. Start a simpler and more respectful conversation about divorce and separation now at adieu.ai.
So this is, if you like, one example of an app that's been developed for the family law system. And there are so many of them that are now out there. Again, when I evaluated that app, it was quite interesting because already a lot of people had used it. The business model was difficult though, because it was how do you actually make money out of it? I did a fake divorce myself and quite enjoyed the process. And I thought, yeah, I probably would use an app like this. It's actually quite useful because, you know, I'd get these emails overnight saying, oh, well, you know, we noticed that you've added this, or that you're concerned about the retirement savings, if you like. Would it be helpful for you to talk to an accountant or you know, who has expertise in this matter? And at the same time, there was an unbundling of legal advice so that I could see a lawyer just when I needed to see a lawyer. So it's quite an interesting model. But I think from the perspective of the creators of that app, you have to be commercial and think about how you make arrangements. And I think that what is interesting is that where they've gone to from this point, in that they've now created 2 other forms of AI. One of them comes off their one-click disclosure. So if you're in a divorce, you provide consent for all of your bank and financial records to be shared with the form of AI. You know, the husband and wife do that. And then the AI goes in, automatically gets access because of the arrangements that they've made, creates if you like, a folder of materials that's all chronologically linked, it's paginated, summarizes all of the materials, produces a prospective budget and produces a budget for the past 2 or 3 years so that you can see who's made contributions, but also you know, how the family budget is working, and can provide guidance in terms of the amount of money that would be available for 2 separate households to exist into the future. Now, it does all of that in 15 minutes. And lawyers, when I talked with lawyers about this, said it usually takes us about 6 months of sending PDF documents backwards and forwards. And then, of course, you've got to get a human to paginate everything so that it's ready for a court environment and so that it's able to be understood by a judge. This is a significant saving in time and cost. The lawyers liked it and actually came on board, I think, with that model. And they came on board also with an AI paralegal model, which they've also created, where what you're actually getting is a summary of every case event every week that's recorded. You get a summary of where you are in the file, and you get a summary of the things that might need to happen next. And it's all linked. It's really easy to turn it into something that can be sent out to a client, and it's much cheaper than, of course, paying for a paralegal. So these kind of modifications already exist and have been built in relation to what I call justice apps. The question is, how might judges use these sorts of apps into the future? And I think that's what's really interesting, because at the moment, the way that judges are supported around the world varies considerably. Many judges have courts which have what we call legacy technology systems. They're very old systems that were built sometimes 20 years ago, and the response, 20 or 30. And so the response has been often to try and bolt new technology on, which hasn't necessarily functioned. However, these new supportive and replacement technologies offer a great deal in terms of how judges might do their day-to-day work, in terms of organising materials, particularly if they're getting materials from lawyers, but even for self-represented litigants, to assist people to be able to organise materials so that it can be logically put together with the assistance of a human, but also with the assistance of a form of AI. So I'm now going to go to the more disruptive technologies and talk a little bit about what's going to happen with those disruptive technologies. And look, it is really an evolving concept. And I've just reviewed the Cambridge Handbook of AI Ethics and Law, which was quite a complex task, but it was made more complex because nearly every contributor of a chapter in that handbook defines AI differently. And also when I've looked at the EU various regulatory provisions, it's defined differently by different entities within the EU. And so it's actually quite hard to say what AI is. But it is this notion, if you like, of another form of intelligence that can assist humans. And I call it assisting rather than necessarily entirely replacing, because it's a combination. So what will a judge look like in 10, 20 or 30 years' time? I have no doubt at all that AI will replace some judges at lower levels. And that's already happening in some jurisdictions. So in England, for example, that they already have AI that's being used in relation to traffic fines, and they've just rolled out some AI in relation to whiplash cases. And we're going to see more of that AI where you're really relying on written material and textual analysis, which creates an issue in the context of a digital divide, because some people are not as able, if you like, to put together material or to actually create something that can respond. But at the same time, I think we'll get more of that evolution of the do not pay and associated systems that hopefully can support self-represented litigants. But there is a real change and a significant shift in how lawyers and indeed people in society are using technology, and courts have to not only keep up with this, but they have to actually consider how they're going to use this for the advantage of litigants, and also to actually meet the objectives of the justice system. And the objectives of justice are always quite difficult to actually, you would think that when we talk about justice, we would have a common view about what justice is, but in fact, that's not the case. Some people have a very narrow view and some people have a much broader view. I tend to have a much broader view, I think, of justice. But when we're talking about, for example, participatory justice, then we need to think about that in the context of technology. For some people, though, I think there is a need to look at speed and cost. For example, if I have a very simple contractual debt matter, and I've got the option of perhaps progressing before a judge, which might take 6 months and which would involve a lot of written material and probably an inability to track what's going on and not necessarily updated case management material. And then, there might be a hearing in a courtroom before a judge. I could either do that, or if I've got an option of actually having an AI judge that might determine the matter on the basis of the written material within 24 hours, I can tell you I probably prefer an AI judge. If, however, it's a complex family matter where there are some really significant parenting differences, then I would probably prefer to have a human being. And I think this notion of human preference is very important in terms of our design for the future. There are some instances where you would look at more therapeutic judging approaches, for example, because that's going to be appropriate in the context of compliance with outcomes and also behavioural change. So a lot of these questions are, I think, complex, and some of the questions are complex as well because, as I noted before, AI is complex. This graph of AI at the simplest level, John probably has a much better picture because he and I were both involved in this project. And this is actually an expert decision tree that we constructed 2005, where we built an expert system, if you like, that could determine really issues around bail, but also potentially issues around sentencing. But it was quite complex. This is only just a tiny piece of what is a much, much larger system. Of course, now when we're often talking about AI, we're talking about machine learning, where we're talking about how it is that machines interrogate and gather data. And there's loads and loads of issues with that in the justice system, because primarily in my own jurisdiction, we're looking at the reasons for judgment that a judge decides as being one of the sources of data. And of course, that's terribly incomplete, because other research that I've done, where I built a web crawler in 2016 and looked at all of the cases that went through the Supreme Court in 2 of our big jurisdictions in Australia. The web crawler was built, and it really showed that the very small percentage of civil cases that ended up before a judge were aberrant. They were aberrant for a number of reasons. They had high levels of task complexity, or what I would call high levels of behavioural complexity, or both. And so if you're building a machine learning system based on that sort of data, it's actually only looking at aberrant court decisions. So it's going to be problematic. It's actually not going to be a very good system. So you have to look at bigger pools of data. And one approach, and I was discussing it with John yesterday, was to actually build a machine learning system, and then you build an expert system that sits outside of it that checks, if you like, what the machine learning examples is, and gives you something within a decent parameter. And I think that's probably a way to progress this if we're looking at serious AI use in this justice or court environment. We need to have that checking. And when I say an expert system as well, I don't mean that it's just asking judges and lawyers, but you actually need to consider self-represented litigants, and you need to consider cultural context and a whole lot of other pieces, so that you're actually building something that is responsive, if you like, to broader questions. So what are some of the judges? Will judges be phased out? Yes, some of them will, but judges still have a really important role in terms of very complex interactions in respect of case management, where in fact most matters, civil matters in my own jurisdiction, are resolved in that either before you even get near a court, because we have mandatory pre-litigation alternative dispute resolution, and again when you get into court. But a lot of matters will also settle because of the conversations that people have on the way through to a hearing. Judges also have a lot of interaction with experts and lay people that are really critical in defining issues. They also have communication and skills focus, particularly in criminal courts, and particularly when we're looking at problem-solving courts. And problem-solving courts are increasingly used in my own jurisdiction. There's more than 240 problem-solving courts in the US, by way of example, and they are really focused on reducing recidivism and dealing at the core issues that a person has, which are often drug and alcohol and mental health related issues. So these are sort of quite important functions that can't be replicated by forms of AI. So then the question is, where do you use AI and where do you not? And I'm just keeping track of time because I've got nearly to the end of this. There are other issues which I'll just touch on briefly. Some of those are around legality of decisions, and that's going to be more problematic in Europe than it is in my own jurisdiction. And again, you know, judicial independence is actually a critical issue. Then there's this question of how you can translate law into code. We have a very big rules as code project underway in Australia at the moment to try and convert a lot of legislation into code, so that in fact it then becomes more machine readable and you can do more with it. That again can be problematic too, because there's a level of discretion sometimes in how things are written that are really evidence of a democratic struggle. Discretionary judgment is a big piece as well, in that at the moment, and I think some writers talk about having you know, different levels of discretion embedded, and that in areas where there's high judicial discretion, then you don't look at a judge AI process, but you might look at it where there's little discretion available. And then, of course, explainability. How do you actually explain something? A lot easier if you build an expert system alongside a machine learning system. I've just put these up here, and I'm sorry that you can't see the top one, but these are some of the triage questions that I've put together, and it's just extracted from my book, which is why it's not done as beautifully as it should on a slide, but it probably could be. So I think, you know, the first factor that you can't really see there is if you've actually had a form of AI make the first decision, then it probably needs to go to a human judge after that, rather than an AI judge. We already have forms of AI making decisions, for example, in insurance property claims. So if you have a car accident and you've got property damage and people are not agreeing in the context of insurance, then we frequently will have AI determining those matters already. If that's what's happened, then it probably should go to a human judge next rather than another form of AI. Is a party vulnerable? And if a party is vulnerable, then that might be an indicator that a human judge is needed. If there's a continuing relationship between the participants, then a human judge might be more appropriate, because you can actually look at how the relationship can be supported or mended or dealt with in some other way. Are there high levels of complexity or novelty? If there are high levels of novelty, then it probably in most common law systems would be more appropriate to have a human judge to develop precedent. Are there high levels of emotion? If so, again, a human judge. And I think importantly, that last question, to what extent are litigants comfortable with an AI judge process? Because at least in the initial stages of judge AI, it really should be a question about whether people are comfortable having a form of judge AI determining their matter or not. Already, and this is from Malaysia, you can see that they've started to roll out AI, not just with guidelines and analysis, but it's actually around replacing some human judges and concerns around that being a soulless experience. I've got to say, in most cases where you're looking at replacement of human judges in the criminal context, it's perceived to be pretty problematic, because you're really not getting at the root cause of the problem. And again, these big issues, I think, that have emerged in China, and when I've looked at China, where you have abnormal judgment warnings, which are really informed by forms of AI. So if a judge departs, if you like, from what is perceived to be the range, then they'll get an abnormal judgment warning. And that's, in my view, extremely problematic. It creates a number of challenges in the terms of a democratic approach, because it's largely been the other arms of the government that have put together the AI, not actually the judges. And so, in a sense, the book that I referred to at the beginning is a bit of a call to arms for judges to be much more engaged and fulfill a role that they haven't really done all that frequently in the past as guardians of the justice system. And I think somebody really has to step up and defend the justice system. Otherwise, we have a risk of it being overly bureaucratized, and I think also transplanting these types of developments from one jurisdiction to another. It goes without saying that in many jurisdictions, people would be very happy to get rid of judges altogether, because they're seen as an impediment for some political systems. And if they're not being gotten rid of, then you want to have judges that agree with you. And one only has to look at the US and what's been occurring there to see that that's the case. The difficulty that you've got, if you've got an AI system which is being built and managed by other arms of the government, then where is judicial independence? And then this is really my last slide, because I note that I've talked over time, which is on neurotech, which is where I kind of started and only where I've been playing while I've been at Oxford on neurotech and judges. And I think there are options. And I'd written an article some years ago called Judge v. Robot, where I talked about it was more likely to be judge and robot with supportive technologies there for judges. However, there was a role for, if you like, an AI judge in some types of matters into the future. I think this idea that humans could be enhanced is one that we'll see a lot more of over the next decade. And you can tell that that's probably the case because you've got these, I don't know, technocrats investing quite a lot of money in neurotech work for the future. And then that raises again a whole series of really interesting questions. In a paper I'm currently writing at the moment, there's actually a part of your brain that is more involved in decision making, and you can track it on an MRI, how developed that part of the brain is. You know, and it raises the question of when we're appointing judges, should we actually have a brain scan and see whether or not they're perhaps more predisposed to making decisions than not. Because one of the issues in a lot of jurisdictions is, of course, delays with judgment. Or do we want the same sort of varied bench that we've had in the past, or do we want quite a different bench again? Again, though, these are really interesting questions around, you know, what is enhancement, and some of the internal enhancements are, I think, fascinating. I probably have a very open view on this, because it seems to me that we've been enhancing people for a while now, and you know, so many people will have something in their heart which assists with heart rhythm. This is something that could assist with brain function, and then to take it to a more logical next step, it might actually assist you in terms of gathering and sorting information, which is, again, I think, quite interesting. But anyway, I've left you with that open and somewhat scary thing. I mean, I wonder about judges wearing something on their head externally to stimulate their thinking. But again, lovely to be here. I thank Fernando for the invitation, and John for he is very kindly hosting me on my weekend away from Oxford. So it's been a real pleasure to be here. Thank you.
Thank you very much, Tania, for your lecture. That really is amazing what it is possible to change in the field of digital justice, and especially the role of AI that can be have a complement for many tasks and many things. And so I'm going now to give the floor to John, because I think that maybe he has questions or something to begin the colloquium. Yes, John?
Sure. Now, we were talking about AI initially, and you've sort of mentioned that in expert systems where humans help design the systems, manage them, and evaluate them, the idea of moving into machine learning is that you don't have this human involvement. And it all relies upon the data, as if data is homogeneous and it actually means something. So, and one of the arguments I've been making, and I'd be interested in discussions about that, is where does legal data come from? How is it different than other data? And does it in fact tell a story? I would argue no. And what do you need to do to have it tell a story?
It's such a great question, because yes, it is different to other forms of data. At the same time, though, we know, any of us who go online shopping now, there is a whole lot of data that's collected. It varies from country to country, and in my own country, it's much more extensive than it is in Europe. At least in Europe, they ask you about cookies, but in my own country, that's not the case. So in fact, there's quite a bit of sentiment analysis that goes on all the time in respect of how I use a keyboard, or even how long I look at a vision when I'm online shopping. And then I'll probably be sent some sort of recommendation if they can get onto me, or something will pop up to say, oh, have you thought about this? Because I've spent a bit of time, they think, looking at it. I've probably gone to get myself a cup of tea, but they don't know that. So there is a lot that will happen, which is beyond looking just at the reasons for decisions and the court file data. You know, it's everything from your keystrokes to your level of engagement that you actually have with the topic area, and whether or not courts will actually understand what's happening in the consumer space, and can we actually build on that in the justice space, is, I think, an interesting question, because it is around the sources of data. It was a fascinating piece when I did that web crawler exercise on the cases in New South Wales and Victorian Supreme Civil Court, because it was quite a high proportion of cases there had actually been a death. It was like something like 22%. This is of cases that progressed through to a full judicial hearing. And I was really surprised that it was such a high percentage. But to actually work out that there'd been a death in relation to these files, the web crawler searched for a whole range of words, and they used lemmatization to come up with, you know, probably 30 words that can be used to describe a death in some way. So they searched through these judgments to try and find these words, and then found them. And it was interesting because what seemed to cause a delay and what seemed to cause these matters to progress through to a full hearing wasn't necessarily the death of a party, a death of an expert, the death of a lawyer, the death of anybody involved in the case, including if it was a probate or related matter, was something which appeared to add to the complexity overall, and the matter then progressing to a hearing. So I think there's a piece there where you can interpret data and get very interesting findings, but you need to have the human to help interpret those findings. I would never have found that, though, without having done that data search, because to actually look through those hundreds and hundreds of cases would have been extremely difficult. But a web crawler, as I said, could be built to look at the free database, because all of our judgments are still free judgment material. And again, it would have to be quite different in different jurisdictions where you've got different ways of writing judgments. But it is hard to interrogate language. And I think one of the issues that we also face at the moment is that there is a real bias in terms of how systems are being built. And you know, of course, we all know about algorithmic bias and, you know, the Compass sort of example and the Loomis decision, but algorithmic bias in terms of what's actually picked up, even in the consumer sector. But things are changing. And so the sources of data, I think we shouldn't just think about text is probably the short answer. We need to think beyond that and what other sources of data are acceptable to gather and could be useful in terms of informing a response.
One of the other things, and this is very different in, you know, common law, where Australia and the US are, and tending to be in civil law countries, is that I think of law, the legal system in Australia being a very open system, so that there are a lot of non-professionals, and particularly non-lawyers, who are involved in the system, and particularly self-represented litigants, people who can't afford lawyers, do it themselves. Now, in Europe, and speaking a lot to Fernando, it seems to be as every legal issue requires lawyers to be involved. So the question is, what happens in Europe if you can't afford a lawyer? Or does the case just never go on? Is there no action? And is there any use? I mean, in Australia, I think there's a real benefit. You've been writing about this, for self-represented litigants to get knowledge. What happens if you can't do it yourself?
Yeah, I mean, I think that's really why the adduce system was built, because it's actually designed to support people who don't have legal representation, refer them on to a lawyer and have unbundled legal advice only when it's necessary. But I think the great thing about systems like this is that they actually populate all of the court documents in the background, so that when you go up to get a consent order in relation to a settlement, everything's already populated and filled out and checked. And so there've been, you know, hundreds of consent orders that have been generated by these systems. And so for self-represented litigants, they can be incredibly useful, because they help people organise, they help people understand, and then they can support people in that. You didn't see it, but, you know, one of the questions, for example, is if you disclose, and by the way, you talk to the robot rather than actually have to text the robot as well. So Lumi has quite good voice recognition technology. So you can talk to the robot, and the robot can have either a male or a female voice, which I think is hilarious. But you talk to Lumi, and Lumi will say, oh, you know, can you tell me a bit about yourself? And you know, and where do you live, and how old are your children, and do you remember what their birthdays are? And all of that stuff is then being pumped into the system to generate these documents that might be required afterwards. And so it really is, I think, supportive. And I'm surprised to hear that about Europe, because it's not something that I had really picked up on as well, even though I've travelled here quite a lot, the importance of having lawyers, because in a sense, so much of our work has been on how to simplify the system so that in many instances people don't need lawyers and can do it themselves.
Well, I'd almost like to ask the audience,
Yeah.
Is what I'm saying true? Am I misinterpreting the situation?
Yeah, I have two questions. One is related to, we were talking about this application for just separation, like
Yeah.
things. And I was working involved in a European project about how the people see the use of technology to solve different problems. No? And we found a link between what kind of problem they wanted to solve. No? When they are very passionate and very human, normally they don't want it that the technology make a completely rational solution for them, because people are not right. Again, our feelings, they are not completely rational. And do you have any feeling about divorce? Because divorce is not like something about a car, something like that, and it's something like no divorce. Have plenty of feelings. You have also the children involved, that kind of things.
I think
It's not so easy, no?
Yeah, I think what was really interesting with the ADU sample, and I did a study of the first 1,000 odd matters that have gone through ADU, was that there was a really high percentage of people who used it who'd been married for more than 25 years. So many of the people who were using that system didn't have young children anymore. And so, but again, even with this, you know, the triage was that if, for example, in my discussions with Lumi the bot, my children had been a certain age, inevitably I would have been referred to a parenting expert who would have given advice, who would have said, would you like general resources on the impact of conflict on children aged, you know, 10 to 15, my age group. So I would have gotten general advice, but I also would have been referred for specific advice. Now, there was nothing in that system that stopped you being referred out to a mediator to deal with that dispute. And there's nothing that also stopped you from getting into the court system if that's where you wanted to end up. It was, though, very much around, do you really want to spend your money on lawyers rather than your children and your future, is probably the angle that they took. And I think it's a very appropriate angle. I mean, I've raised that in mediations that I've done myself. You know, do you want to send the lawyer's children to a private school, or do you want to send your own? Because that's really the question that sometimes arises. So I think there is utility even where you have high levels of emotion in having apps that can help support people through that process. And in fact, another app that I've worked on called the Bernie app is designed for domestic violence offenders. And what it does is, who are usually male, what it does is give a lot of resources. It keeps all their court dates in order, and it gives them support services before they go to court. And the reason why that's a particularly useful app is that it's actually shown to help prompt and nudge some behavioural change amongst those domestic violence offenders. So even when you've got levels of violence, it's better than nothing, in my view, and it's a way of providing support that people may not feel as embarrassed about taking up as well, because sometimes people don't get support or don't necessarily access services that they need because they're embarrassed to do it. There's also another app service which joins up everybody's appointments. So if somebody, for example, has mental health issues and they're a hoarder and they've got a whole lot of other issues, it can help provide people who will go directly to that person's house, and it will ensure that, for example, a person doesn't have an appointment at 2 o'clock on Monday with some agency and some organisation, at 3 o'clock on Wednesday, and at 10 a.m. on Friday. It will actually group everything together for them so that they can just go to one location, have all of the appointments there, and have reminders as well coming through on their phone so that they're not missing things, which is really important if a person needs that kind of mental health support. And it's often not what we think about. We think, oh yeah, we've done this referral for this person and they've got these appointments lined up. But if they're not actually ever going to attend the appointments because it's all too confusing and it's too complex, and they only want to get out of the house one day a week because that's all that they can manage, then these kind of apps can be really quite sophisticated and useful. So that's a very long-winded answer. But it is funny too about what people like, because there's another app that couples use before they go into marriage, and it's supposed to be an app where it helps support marriages in the long run. It's kind of like a counselling app. But I had this image of two people sitting in bed on their phone, working on the app, actually talking to one another. So there is a bit where you can't clearly replace all human conversation.
And the second one, as a criminal lawyer, do you think it would be possible to use AI system in the criminal law, procedure? I mean, in criminal law, we are playing with the highest human rights, no? With the liberty, freedom, that. And do you think it would be possible, or is more restricted to private things and that kind of?
I think it really is a system design question. I mean, we know that, for example, judges may not make good decisions when they haven't eaten, they haven't slept well, or we also know that social attractiveness can play a role. There are probably at least 10 factors that can influence a judge in terms of a decision around sentencing, but even in relation to how they might deal with the criminal matter overall. I think there's a role for supportive judge AI in respect of criminal matters that can help judges better understand what might be a normative decision-making process. The issue that I have, though, is that many courts are underfunded. Often there are not enough judges. And that if you have, for example, a supportive judge AI system that spits out a template of what would be normal for very busy judges with low budgets, it's likely that that might replace judicial decision making and also bring on an anchoring effect. You could, I think, get around that by ensuring that you still have systems that adequately support judges, and you don't assume because you've got supportive judge AI that a judge who might be dealing with 2 or 3 matters a day can suddenly deal with 20. So it is a system design piece as well. I am very concerned, though, around the systems that I'm seeing emerging in China, which are also using the social credit system to actually determine some of the sentencing. So that's part of what's there. So your guilt or otherwise might in part be determined by a social credit score, and the sentencing options might be in part determined by that. So I think we have to be very careful around how these systems are designed, how we define justice to begin with. And also, I think, you know, coming back over the next 5 to 10 years, in particular, thinking of litigant preferences.
Can I just say it is possible for AI, in fact, even I could do it, you don't even need AI, to make a decision on every single issue. The question isn't whether you can make a decision. The question is how good that decision is. Are you going to evaluate it? Does it fit in with your moral code, with ethical values, with human rights, things like that? Now, the complexity of criminal law versus some sort of civil law, and particularly with road traffic, is that you have more rights and more values and different onuses. So it's really not a question of whether AI can give you an answer, but whether how good that answer is, how you're going to evaluate it. And do you in fact want AI doing it, or would you rather have a human delivering it? So I don't think any of the issues, this is where we're getting into different disagreement, are technological. The issues are, how do you use it? How do you use the interfaces? How do you evaluate it? So you don't need the most modern AI that can deal with millions of cases and do it incredibly quickly. It's how you get people using it that's the problem. Zana.
Hi, thank you very much for your very interesting speech. You definitely touched upon a certain number of subjects that I would like to deal with right now, but just going a little bit to John's comment and question, you opened it to the floor, and I think that part was not clear. When you look into common law versus civil law and how pro se arbitration or ADR in itself is basically in the limelight, whereas in civil systems it is not quite. In the case of Spain, we're asking about that. Certainly, if we're talking about small claims proceedings, then there would be a possibility for yourself to represent yourself in this case. But my feeling is that certainly civil law systems the focus is placed primarily on regulation, public regulation, rather than private-public cooperation or partnership. So the amount of apps that you have just spelled out, I mean, it's impressive, and the potential that they may have, obviously, in advancing justice is tremendous. However, I do feel that in Spain, for instance, steps are really, really small in this respect. Then the public sector is very reluctant, perhaps, to open the gates towards not privatization, but definitely the use of technology without having had, obviously, a proper regulation, express regulation on the matter. Going back to criminal proceedings and the use of apps, you said something before that was very interesting, the use of data, not only textual data, but facial expressions, gestures, etc., etc. Just think of the potential that could have in criminal proceedings, and analysis of visual data, photographs, videos, etc., and obviously how that could be used not only in judicial proceedings, but also parallel proceedings that have been developing furthermore in today's time. If you look at popular courts, obviously jury, etc., the use of AI tools can be tremendous and effective, you would say. My question, however, is a bit related to another field. I'm more interested in how we would see AI function in international litigation, such as, for example, in the field of trade, or international investment, or even human rights protection.
Well, thank you for that incredible series of questions and also commentary, and I do want to thank the audience. I think the first matter that you commented on was really the regulatory environment in Europe and how that may mean that things don't develop in the same way that they might in other jurisdictions. And I think my observations are probably in accord with that as well. In a country like my own, where we have very little regulation, you see all of these apps develop. I can only hope that once they've become more sophisticated, then they'll probably be transplanted and used elsewhere. But I do see that sometimes the regulatory environment might be a real impediment in terms of innovation in this area. And on the one hand, that's a good thing, but on the other hand, it will cause issues into the future. I'm going to start with your last question and comment, which was really around international approaches. And I think we're at such an interesting point in time in that, really over the last decade or so, we've had a number of conventions and free trade agreements, which really means that many of the large corporates aren't even engaged in domestic litigation now. They're off doing their commercial arbitration or dealing with disputes in quite different ways. And that is a more significant issue, I think, than really considering the use of technology, because what we're of course seeing is that people are challenging domestic legislation, which might be protecting the environment or protecting human rights or protecting health, and it's being challenged on the basis of free trade or other agreements that exist. And certainly we're not immune to that in Australia. When we introduced plain paper packaging for cigarettes, there's a great example of that where Philip Morris, the large tobacco producer, commenced more or less litigation, but arbitration proceedings on the basis that Australia was in breach of its fair trade agreement because it had implemented this approach, which was designed to protect health. Australia won that case, but it only won that case after expending more than $250 million. And it replicates other cases, of course, around the world. In Canada, you've had the big pharmaceutical companies who have been commencing litigation for years against the Canadians because they're selling things at a much reduced price in terms of pharmaceuticals. And you also see in South America a lot of the big environmental polluters where you've got domestic legislation that's been introduced and then they've gone on to international arbitration to say you can't have this domestic legislation because it impacts on our rights of, if you like, trade. And so we already have this very difficult situation, I think, that's emerged where we have governments entering into conventions and treaties under certain circumstances and perhaps not fully understanding the limitations that exist. And, you know, I have a bigger view on that where I really consider that there are significant issues with that interference with domestic legislation, particularly where you're looking at health, the environment and labour rights. I mean, there are whole categories of matters where there should be carve-outs. But again, that's probably really up to those that negotiate these arrangements rather than myself. I think the issue, though, that you're probably talking about is what I would call the digital Switzerland issue, which is where you've got these massive tech firms that are bigger than most small countries and who really have enormous capacity to do whatever they want around the world, often not paying much in taxes, if anything, and often setting up their own dispute resolution systems as well that are quite frankly a bit worrying, some of them. I think, you know, sort of having to have to arbitrate in particular areas or having to have to do something else because that's where really the digital tech system has taken us is problematic. And there's been a very much a self-regulatory approach in relation to them. And we can see that can work on some levels, but again, watching the Twitter sphere over the last month or so really takes one it makes one think, well, it's all very temporary. You know, you might have had some content moderation and some procedures in place in relation to abuse, but they can evaporate very quickly in the face of strong tech-related personalities. So, yeah, look, the system is changing, and each of those two, I think, features really means that domestic systems are playing a very different role into the future. And there is a continual encroachment that I think most lawyers and judges are completely unaware of. And so I think that's a threat as well, because it's a threat to the role that an independent judiciary plays. If you carve out whole areas of law and say, look, this is going to be dealt with in an international arbitration setting, or if you carve out whole areas of, if you like, complaints and disputes and say this has to be dealt with through a particular system that may or may not be effective, then I think it's problematic. Again, it requires more of an international solution than I think just one domestic solution. But it's a great question, and it's a bigger question than probably looking at AI. But it's a big question in terms of the tech giants and their capacity to change and reshift. I am worried about the role that they might play in setting up AI judicial systems, because I could see that could be an area where there could be significant encroachment. And I do worry as well that it might be big tech who determines the parameters rather than judges, which is why I'm so keen on an activist judge approach and judges being more engaged. And in many jurisdictions, judges just traditionally have not engaged in these kind of policy discussions or debates about what the justice system looks like into the future. But I think they need to.
Definitely the dangers are obvious here. You did refer to different states that may profit from the introduction of judge robots or robot judges.
Absolutely.
Look at obviously all the Asian, even African, Poland, not to go too far, Hungary, or obviously Russia or Belarus, etc.
Yeah. Definitely. Judge AI systems can support a totalitarian regime, particularly if the AI and the systems are built by those with morals and ethical approaches that are inconsistent with, a rule of law approach.
Last but not least, we're referring to the interpretation. Definitely interpreting legal norms, legal rules is key when devising AI variables in this case. What do you think the role of judges or academics would be in perhaps designing the AI tools and systems in order to perhaps utilize it at its most, and obviously you have different layers in terms of how much one could use AI tools in order to process data. Interpretation is a big part of it. Talking about text data, for instance, if you look into, again, international agreements or international jurisprudence, obviously the volume is immense. So, but there's still keywords or standards that are applicable, independent on what's the style of the sentence or the ruling, etc., but they can be replicated or can be identified, obviously, language barriers can also be an issue there. What would you feel the role of professionals, judges, academics, etc., would be in perhaps designing that technical layer of AI tools in order to process the information and identify the correct data that afterwards, practitioners, for instance, or judges could just manipulate instead of spending 2 or 3 weeks analyzing the data in your band of seconds or hours?
It's a very interesting question, because and it's probably worthwhile to engage with the whole rules as code movement, which is, I think, grappling with some of the interpretation issues. But it does come back, I think, to this question of if you're going to adopt a sort of machine learning approach, should you alongside it have an expert system, which is really, I think, what Jonh and I would suggest, is that you build an expert system that is informed by these various experts, and that is the check on the other system that you have operating. And it also informs, by the way, the decision in respect of the machine learning, although it might be that they're quite two independent things. I suppose I was looking at it a little bit more broadly than Jonh, only because I'm very interested in the kind of whole human-centered design approach in general. And therefore, I wouldn't just include the judges and the lawyers and other sort of folks, but I'd include the users and even the non-users of the system. And that's partly because you want to pick up on the language differences, as you've highlighted, and also the cultural differences. So I currently have a project working with Indigenous Australians, for example, and it seems to me that some of what is considered there might be quite useful to build into a system which was actually able to attend to the needs of more within the society, and actually might consider how you meet justice objectives more broadly. But I think the first step is, what are actually the objectives of the system that we're looking at? What are the sub-objectives? How do you go through to measure those? And then from there, take it to, okay, what does the legislation say? What does the case law say? How do we build an expert system based on that? Bearing in mind those bigger overarching, if you like, objectives. And that's what's got to be kept in mind, I think. So I hope that answers your question.
Well, thank you very much. And I have 2 comments. One is concerning the place that emotions is to take into this debate, which is astonishing. Because I think from a common law tradition, clearly well, at least I think clearly this approach to the legal realism, this idea you mentioned also, when Harry made a comment on the probability of using artificial intelligence in criminal law, he mentioned the idea that judges may be influenced by, that is very much your tradition, it's not my tradition, so it's very much the idea of the legal realism, the idea that it doesn't matter what is in the law, what is the word of the judge, it matters what is his doing, what he has eaten, what he has, the education he has had. But that means that at the end of the day, the law is nothing, because it's disappeared in the void, because what matters is what he has eaten, not what he is reasoning. And that is a tradition completely different from our traditions, from the tradition of continuous law lawyers. which is very much based on the legal discourse of rationalism, but not the kind of only legal reasoning, only legal syllogism, but it's something connected to called Habermas tradition of discourse theory and the legal reasoning, which is also some of the open texture of the law. But I mean, I'm very puzzled because on the one hand, we said that judges is what they have eaten, so this is the stomach theory of legal reasoning. And on the other hand, we said that emotions play a role also in the application or not of artificial intelligence. That is really blows up my mind because it seems to be two completely contradictory positions. So let's cite outside, let's put outside emotions, and on the other hand, let's have emotions into our discourse. That's one thing. And the other one is about interpreting and the open texture of words, of language, the idea that when we give meaning to word is something, is a essential human activity. So because it's related with the values we share, with the morality we have, and that is something that is human. So this legal interpretation is a political activity, is law, is a human based activity, and I don't still see how that can be replaced with that. And if it is, it's bad, it's something else. So it's not interpretation, it's something, and we change our legal model, which is fine. Probably we are on the edge of a new paradigm of law and legal reasoning, but I think that we have to also set the limits of artificial intelligence when it means law. So they are not only, we talk all the time about the problems that the judges have or the courts have, or shortage of time, of sources, of knowledge, but we don't speak about the limits of artificial intelligence, and I think that is the one.
Thank you for each of those comments, which I thought were very interesting. The first one I might go to, which again, it's almost as though we sometimes talk at cross purposes, I think, when we talk about each of our systems. The study that was done on judges, which some people disagree with about the time that they were eaten, is known as the Israeli parole study. And it showed that judges were much less likely to grant parole in certain decisions when they hadn't eaten or when a certain time had elapsed since breakfast and lunch. And some people have said, look, that study is not that good, but others have said, yes, I think that this is correct. And so it wasn't from my own jurisdiction that the gut, if you like, the stomach appeared to have an impact on judicial decision making. I do think, though, that the way that you've described what happens in Europe is very interesting for me as a non-European academic, because I mentioned that I've just been doing this review of the Cambridge handbook on ethics and AI in the legal context. And it's fascinating to me because, of course, I've been reading all of the European scholars who have a lot to say and all of the non-European scholars. And it's so different, their views of AI, and in more often than not in the non-European world, there's a kind of sense of optimism. And for a number of the Europeans, they're very pessimistic and are very concerned and sort of imagine cyborg approaches. Not all the time, some are not like that. But one of the European scholars in particular made the point that they didn't think that you had to have regulation that had been developed across Europe, in particular in respect of torts and other areas, because you didn't have the same deep philosophical discussions about torts that happen in the non-European setting. And I thought that that was a fascinating comment to make. And in the context of the regulation that has been developed in the European setting as well, it sort of is almost opposed to the perspective that you have these kind of more philosophical understandings, because everything, it seems, has to be converted to regulation, and some of the regulation is inconsistent with the other regulation that's being produced. And it's quite hard as an external person to understand this. And I think what I've taken away from some of this discussion and debate is that the EU has come together, and what you're seeing is, in respect of the different regulatory forms, it's part of people actually coming together and reaching consensus about views, and that process of itself as a collaborative, cooperative process is really critical in terms of developing thoughts about how this should all run into the future. And so that's kind of one piece where I think those conversations aren't happening in some other countries, where it's just a view that, oh, we've got these general broad principles that guide our common law approach. They'll be sufficient to actually deal with AI. And if they're not, then we'll come up with something. And we can always look at the Europeans and see how they're going and maybe borrow from them if that's appropriate. That seems to be the kind of approach that's being taken. I do think that, though, there are fundamental differences in jurisdictions about how the role of a judge is perceived. And we actually have what's called the instinctive synthesis theory that applies to judges, which has basically been accepted by our High Court, and accepts that judges have almost a gut response to something, and that's okay for a judge to have a gut response. You can't ignore the rational and logical reasoning approach. However, this instinctive synthesis approach, which came out in a lead case of Markarian and Crown, is like, really accepted that, yes, you have this gut approach, and that it is okay for judges to have this instinctive synthesis, which comes out of their experience as a judicial officer of usually many years. And so it's a very interesting approach to say that there is no exact recipe in a case that you can follow. It's going to depend a lot on the ingredients that you use in the recipe. I think whether or not the judge is hungry is also part of how well that will go.
This is the career.
Yeah, it is. It is.
The guts theory.
The guts theory. Yeah.
Yeah.
Yeah. So it is, I think, a difference, and a cultural difference in how we see things.
It's more the theory that there are other factors rather than the facts of the case that influence the judge. I mean, lunch is only one issue, isn't it? It might be appearance.
I know. The thing is that it's true. So probably a judge provide more broad after eating so what. So that is not relevant in the sense that it's relevant from the point of view of legal protection and judicial protection is the justification. This is so the wishes that the judge have is our tool to defend ourselves. But if that's why I said legal realism condense up to the void, because if we don't have legal resources to strike back, so we are harmless. That is that is why I don't understand why people who defend that they place the role of artificial intelligence in law embrace legal realism approach. So that is just it is against the nature of law.
Yeah, and I think you're absolutely correct, which is probably why I have those triage questions and really say, yes, complete replacement might be appropriate in relation to some categories of matters, but not others. And then you would look at supported judge A and I in others, and then you may look at human judge approaches only in others. And I think the difficulty is always trying to sort out where you have that, because I agree with you that if you're looking at a judge-led system, a court system, you are actually trying to encourage that justice values are disseminated amongst the community and also between people. And so you go back to Plato and Aristotle when you're really looking at what is the justice system for. And it's probably why I say, let's actually work on what those objectives are first before we go to the next two steps. And I think in every society, there will need to be a number of contextual changes made. So you've got an overarching piece, and then you think, okay, how does this impact on an individual litigant? How does this impact on the sector? How does this impact on society? And to do that, I've found it quite helpful to look at levels of abstraction in ethics that are used in the medical field. I've found them more useful than anything I've found in the legal field. So these are, I think, interesting questions around how we design something that can actually be used into the future and is culturally appropriate, given, I think, our very different approaches. Yeah. Thank you.
Thank you very much, Leonor. Indeed, this is a debate that is on the table. It is clear that the cultural references are different in many countries. In particularly in Europe, we have follow the regulation, and I think that we have the European Commission of Human Rights always in the top. For instance, in the European Charter for the use of AI in the justice field and in the environment, when you read it, it is reluctant to use the AI systems in the field of justice. But this is the departure point in Europe, and it is clear. But at the same time, I don't think that this point of departure is bad, because the Europeans also have wants to progress and to learn, and really the systems are more and more perfect. We can even more and more have knowledge of the possibilities and the limitations of the systems, and this is a way who could help a lot in order to have an effective governance and control of the systems. So it is even if the position of from Europe is at the beginning reluctant, but it is clear that, for instance, this year in Germany, that was presented a project. The name is Frauke. Frauke is a project that they have launched in Germany in order to help judges to support them in order to have what should be the right to compensation only in the field of the flight claims. Flight claims for passengers in the topic of cancel of flights or delay of flights, and so at the same time that the position of Europe is strengthened, but you can see that also they are having progress in certain things. Indeed, the question that I would like to ask you is, didn't you have recommendations? Because the AI things affect many tasks, and it's very broad. But then you have recommendations because at the end you have public decisions in order to impulse the use of AI systems. It would be possible to have recommendations in order to how to start and how to in which sectors we should use it, or we should begin to use this kind of machines, because at the end it's a question of technology, but we have to begin from one point.
Yeah.
And what should be the recommendations in order to impact the public policy in this field?
Well, that's a huge question and a really interesting question to ask. I mean, I think inevitably the focus is going to be more on the supportive and replacement technologies over the next 5 to 10 years, and that really there are enormous benefits for the judiciary and for litigants and for representatives in relation to all of those categories, because I think there's some really exciting work underway. In relation to AI, it's very difficult to respond adequately to that question because, as you've pointed out, it is a different environment that's happening around the world. I think the first thing is that it's probably useful on an international level to consider a broad-based ethical framework, and in a way the EU has already done so much work in that area. It's not impossible, I think, to pull that material together. But because it is so problematic, the notion of power and control, and it's also problematic in terms of the capacity of a lot of AI systems, that we need to consider, I think, these questions on an independent jurisdiction basis, but with having a shared ethical framework that binds all, if you like, court and judicial systems into the future. And it's got to be flexible enough so that you have those countries where you already have significant inroads being made, feeling that yes, they can consider it. For Europe, it allows you to do the high impact, low impact kind of study work, which is, I think, critically important in Europe. And for my own jurisdiction, it enables you to build in the peculiarities of your own jurisdiction if it's broad enough. And I mean, it's one of the reasons why I was looking not just at these kind of like catch-alls of fair and transparent, but very much looking at what levels, and these levels of abstraction, I think, are as important as the actual meaning. I mean, one of the issues that you have with the sort of motherhood statement about something being fair is that what it means is really unknown. Fairness, you know, are you talking more about procedural fairness, or are you talking about, you know, something else? And so I think there are these issues that need to be worked out within our own environments, and often we've never done it. You know, we have justice systems, and yet nobody really adequately defines justice, or not in many places. And so it takes us back to a table and a different conversation. It ought not to slow developments, though, because we should be developing things in the supportive and replacement areas. And there, I think you're looking at self-regulatory regimes, and you're also looking at what I call light touch regulatory arrangements. And we had that conversation about light, medium, and high touch not long ago. And really, in relation to some of this, nothing will grow or develop unless you've got a very light touch approach. You know, you want to be protective, but at the same time, you want to encourage growth. So that's a very long-winded answer, but I think you've got to start at that point, which I think EU has started at, but hasn't necessarily developed or given. Well, but perhaps really that's what the high impact, low impact approach is intended to do, is to encourage people to then take that further. I would have probably looked at the levels of abstraction a little more, but that's another matter. So I think it's an exciting time. It's an exciting time to be in law. It's an exciting time to work in justice.
Thank you very much. Do we have any question in the chat or in streaming? Thank you very much, Tania and Jonh, for sharing with us today. It was a pleasure, and I'm going to send greetings to people following this event in the streaming. We are going to finish. Thank you very much.
Thank you.